Our next case is NH et al. Versus, what I'd probably say, Soisi and very wrong, and I apologize on the record for mispronouncing that name, et al. Each party will have 15 minutes to present their argument. Council Hall, would you like to reserve for rebuttal?
I guess 10 minutes.
How much?
10.
Well, 5 is our max. So.
5, I'll take 5. 5's the max, I'll take 5.
We'll down to 5.
All right.
Arguments are being recorded. When you come to present your argument, please make sure you stay behind the podium. Please introduce yourself for the record, and please speak loud enough so that the recording can pick you up. You should not use the name of any child, minor, or victim like we have here. We're using the initials in this case, and that's certainly fine, or any other way you want to designate someone who is a child, minor, or victim would be fine with us. We have read your brief and are ready to proceed whenever you are. Well, Council, by the way, that top circle is the one we're using for you. I'll try to remind you when you get about a minute left, and you're of course the middle circle there, so I'll try to remind you when you're about a minute as well. Thank you.
Good morning, John Lashney for the Village of Lakemore, the appellant in this matter. I'm going to be fairly brief. I wasn't the one that asked for an argument with my opponent, and I think my briefs pretty much, I said everything I had to say, but I did want to raise 5 points. Plaintiff appellees do not cite a single case, not even one, which stands for the proposition that political subdivisions can be sued for intentional torts. Plaintiff appellees do not cite a single case, not one, which states that police services aren't a governmental function.
Counsel, let me just ask you some of the things that came to my mind when I was reading this. Now,
Sure.
I have not gone through the record yet, so obviously I'll be illuminated, hopefully even enlightened when I go through the record. But who all was sued in this particular? I know the city of Lakemore was sued, or the village of Lakemore, sorry about that. But were any of the public officials sued other than the individual police officer here?
No, Your Honor. No, just Officer Soisan, who allegedly committed the tortious acts. He was the only defendant.
So there's 2 defendants, the village of Lakemore and Susan.
Soisan, yes.
Sosan, sorry.
One of the claims.
And obviously he was sued in his official capacity.
Individual capacity, I did not move for judgment of pleadings based upon 2744 immunity relative to him. So the claims against him are not before you today. My appeal and briefing is solely focused on the village of Lakemore. One of the claims that the plaintiff has asserted was that the village was negligent in hiring, retaining, and supervising Soisan. But again, the plaintiff's appellees do not cite a single case that contradicts the House Supreme Court's holding in McConnell versus Dudley that there is no immunity exception for that negligence in hiring and retention of a supervising employee.
Well, that's not an intentional tort, though, is it?
No, I mean, I obviously had to argue that separately. You know, the 3-tiered analysis, which you're well familiar with, involves identifying is it a governmental function first or proprietary. Mm-hmm. And that's why I said that the police services, I think every court universally has said that police services are a governmental function to start with. And then you look at the exceptions in 274402B 1 through 5. Is a proprietary function, you know, obviously this wasn't an auto accident, you know, there's a host of exceptions, but none of them apply in this case. So with intentional torts, with no exceptions, the courts have universally held that you can't sue for intentional torts. With negligence, you have to identify one of those exceptions, but again, none of them apply in this case. So
The plaintiff seems to be saying it's a little different here because rather than going through the exceptions in 02, they're going to 274409E and saying there's an exception for civil rights claims. And this is a civil rights claim, therefore there is an exception.
okay. the 274409E exception applies to federal United States Constitution claims. It does not apply to claims under the Ohio Constitution. And it's not terribly surprising that the General Assembly never included claims under the Ohio Constitution in that 274409E exception, because the court has not yet recognized a claim under the Ohio Constitution, because there is no claim. Typically, most of the sections in the Ohio Constitution are not self-executing. There's two exceptions. Article 1, Section 19, which deals with eminent domain actions and takings claims, which allows you to pursue an inverse condemnation action under Revised Code Section 163. And then there's Article 2, Section 34A, which is a claim for unpaid wages. That permits a direct claim under the Ohio Constitution, a direct private civil cause of action. But, and I've had several of these same cases in a federal court interpreting Ohio law. There's been a number of appellate cases that have stood for the proposition that you can't file a private civil action for damages under the Ohio Constitution. So I'm not sure how 274409E, which essentially completely accepts at least federal Constitution claims, would apply to a claim under the Ohio Constitution.
Let me ask you this. If the village is correct and should have been dismissed from the suit, what happens from there on out? I mean, what's the practical effect of that?
Well, the plaintiffs' appellees are free to pursue their claims against Officer Soyson, who remains as a defendant. These 274402B immunities do not apply to individual employees, and their immunity is under 274403A6. So they would have the opportunity to show that Officer Soyson either manifestly acted outside the scope of his employment or acted in a willful, wanton, reckless manner, bad faith. That's exception.
What if he was acting within the scope of his employment?
Well, that would eliminate that exception. They're in the alternative. They're or, not and. So.
But what I'm saying is, would the village still be involved? Doesn't the village have a duty to defend this employee?
Under 274407, the village would still be defending Soyson. He's not going to be cast off to the wind because under Rogers versus Youngstown, they have a duty to continue to defend him on the basis of, if he has a good faith defense, that he was acting ostensibly within the scope of his employment and not in bad faith, he's entitled to defense, and typically that's not determined based upon the allegations in the complaint. So, it's pretty rare that public employers file declaratory judgment actions so they don't have to defend their employees. Typically, they just wait till the outcome of the case, and then it's determined what will happen at that point. One other point I wanted to make was that the plaintiffs' appellees did not cite a single case which stands for the proposition that a claim under 230760, which is civil recovery for criminal acts, expressly imposes liability on a political subdivision under the 274402B5 exception. It's our position that each and every claim in the complaint is subject to immunity in one fashion or another, and that the entirety of the trial court's decision should be reversed to here today. Unless there's any further questions, I'll pass to the appellee.
Seeing none, thank you. You have your full time for rebuttal.
Thanks.
Please, the court. I'm Ed Gilbert, representing the plaintiffs in this case. I would like to get down to really why we are here. And this is a 12B motion. And what happened here is that you have a well-seasoned trial judge that simply says, and I quote, "This court finds insufficient evidence has been presented to conclusively determine whether Lakemore is immune from liability for sanctions alleged actions." And what happened here, I think that the court needs to deal with this and get some common sense to what's going on here. This is a Rule 12, and we have not had an opportunity to present our case. All we've done is filed a complaint, and the complaint alleges 9 causes of action. We have asked to be allowed to present our case, and the insurance company has now come up with this motion to deny us that opportunity. And I think that you have to go back to really what's going on in this case. We have a police officer that is known to be a bad cop. We have a police chief that has indicated this man is a bad man. He is a bad cop and needs to be terminated. We have his co-workers, other police officers, that are saying, we don't want to work with this guy. He needs to be terminated.
But counsel,
We have all of this going on.
but counsel, the point is, he's still in.
Excuse
The
me?
bad actor is the one that's still in the lawsuit, though.
He is still in the
And-
lawsuit,
and-
but what I'm saying is, what I'm trying to get to, I'm sorry, Your Honor, I didn't mean to cut you off, but what I'm saying is that all these things were presented to counsel, and it was counsel that said, no, we're gonna keep this guy in.
Right, but it's my understanding that you didn't sue any of the officials in their official capacity.
I did not sue them in their official capacity, I sued the village itself. And our contention is that this guy continued under the authority of city council to continue to do what he did. He continued to do it. He has this bad habit of wanting to beat up on 13-year-old young black girls. And he continued to even try to get him into counseling and training. He refused to go. It wasn't until he was a resource officer at the high school and beat up on one of the council people relatives that they finally terminated him. Now, let's get to common sense here. Common sense tells us that something's wrong in Lakemore. Common sense tells us that there are a number of exceptions under the rules. That yes, you have immunity, but immunity we know has several exceptions. All we're saying, and all the court down below is saying is, look, you may have immunity, you may not have immunity, but we need to be given an opportunity to present our case.
But-
Common sense tells us.
In this case, Mr. Gilbert, the question I have is, normally when we see these cases, and they're normally on summary judgment, not judgment on the pleadings,
That's
we see
correct.
the 3-tier analysis, and we don't see that here. So my concern is, what is the court telling us? Is every one of your accounts against the village permissible? Are there some of them, as appellants allege, the intentional torts, for instance, are not something you can bring against the village? I mean, it sounds like you're talking here to me more about negligence, retention, supervision, and so perhaps that count we need more facts on. But if every count should have gone forward, and the court just basically said, well, no, you got to figure out summary judgment for everything. I mean, to me, if there is in fact a count that cannot be proven under any set of circumstances, and there's an acceptance of no acceptance of immunity, perhaps that count should have been dismissed. So I'm not saying you may very well have some counts against the village to go forward with, but shouldn't the court have at least made an effort to sort out those counts to say which one are valid and which ones are not?
I don't think so. I think the court has a right to say, look, let's go through some discovery, determine what falls in, what falls out, and make the call at that point. That's what Rule 12 is all about. Rule 12 is about establishing your general case and giving an opportunity for each side to state their case. I think that every case, that every claim we have here is valid based upon the circumstances of this case. This case is as bad as it gets. You have the co-workers filing complaints against this guy, both civil rights complaints and other complaints, saying this guy is bad, we got to get rid of this guy. And yet you have counsel saying, oh no, we're just going to keep him, we're going to keep him, we're going to keep him, let him go ahead and do his racist acts, let him do whatever he wants to do to young people. And we just turn our heads. At some point, this court has got to stand up and say, look, that's not the intent of immunity. The intent of immunity is not to allow somebody to go on and have some type of criminal act against the citizens.
But if you had sued them in their official capacity, they wouldn't be able to argue this, right?
Well, maybe, maybe not. But our point is that the village that is responsible here, that these individuals allowed, and there was some turnover in the council, but they continued to do this, and this is a village issue. And that's our position on it. And quite frankly, you know, I think we do have some issues here in regards to criminal acts and whether they're responsible for that. We have civil rights acts here under the state statute. And our position is, rather than to go through this song and dance, to try to dance around this, quite frankly, we ought to be given an opportunity to sort this out and shake it down. That's all we're saying. Give us an opportunity to sort it out and shake it down. You know, and 99% of these cases, you're correct, are coming before you in regards to summary judgment. And that's the way it should be. Give us an opportunity to make a case. And that's all we're saying, is that we want an opportunity to present our case. And that's the bottom line. Any other questions? Thank you.
Thank you.
You know, I heard a lot of stuff that isn't in the complaint, isn't in the record. So I'm going to respond briefly to that. As you may be indirectly aware, this case was originally in federal court, and the court threw the entire case out.
But it doesn't matter. What relevance is that?
It doesn't matter. It's just, I have to sit here and listen to Mr. Gilbert give a speech about things that,
well,
quite frankly, have nothing to do with it.
Here's my question. Mr. Gilbert did not sue the individual council members, and he made that choice, that's fine. But he did sue the police officer in his official capacity. So, you know, when we talk about practical effect and everything, I'm just not sure. I mean, even if you win on your motion, what does that really mean? It's still going to be the taxpayers' dollars if the judgment is against the police officer in his official capacity.
Well, it would have to be a judgment against him in his individual capacity because, as the Ohio Supreme Court has said in any number of cases, the state of Piketon, I think.
Well, if he's acting in his official capacity because they tell him that's what he's supposed to do, that's a different issue, isn't it?
For purposes of immunity, no.
Oh, okay.
I mean, you know, the Ohio Supreme Court has made it clear since 1992 in Conley versus Scheer that this is purely a question of law for the court. I mean, either you can bring claims for intentional torts against political subdivisions or you can't. Now, I know from personal experience, having been here once before, there are some exceptions. As I remember, I was here for Buck versus Reminderville, but that was a public employee who was suing for defamation, the employer. And it was a case where I think, I don't know if it was 274409B or C applied. But you know, for public employees, different rules apply.
But I guess what I'm saying is, I'm not talking, I think you and I are talking about two different things. What I'm saying is, if the evidence came out that this particular individual was allowed and even subjected or ordered to, you know, to particularly police black people or something, or to target that, how would that be not in his official capacity if his employer's telling him to do that?
Well,
That's it, what I was just trying to make. I don't know, I'm trying to figure this all out, because I'm trying to figure out, I understand, we can rule, you know, this is legal, blah, blah, blah. What does it really mean?
Well, at the end of the day, what it's going to come down to is, you know, obviously, I know you don't want to talk about this, but obviously the federal court made certain decisions, and there's going to be issue preclusion issues. For example, just bear with me. There was a false arrest claim. The federal court determined there was probable cause for the arrest. So, you know, that's going to have an impact on some of these claims against Officer Soysan.
Maybe or maybe not, right?
The federal court determined that there was no excessive force, that there was no violation of her constitutional rights. So, you know, it may have an impact on some of these claims.
And those would be good summary judgment issues, right?
For Officer Soysan, yes. But for the village...
In its official as well as individual capacity?
I mean, the official capacity gets subsumed into the village.
That's my point, yes.
I mean, under, was it Lambert versus Clancy?
So I'm just wondering here too, I don't know, we usually have a sheet here. Is this one that you guys looked at mediation in regard to?
We tried federal court a couple times.
Okay, but I'm talking about our court.
No.
And you're not open to doing mediation?
There's no interest in that, no.
Okay, all right, thank you.
My point is each of these claims, at least against the village, are subject to immunity. And the trial court should have ruled that way. I mean, I've been representing political subdivisions for 31 out of my 35 years of practice. And in a non-employee case, this is the first time I've ever had a court deny a judgment on the pleadings for intentional torts. First time ever. Never had it happen before. Never had to appeal that before. It's just
never had one.
Never had to appeal it before.
Oh.
It's just it's so unusual. And I think the law is clear that as for the non-intentional tort claims, and in particular the negligence in training, hiring, supervision, those sorts of things. I mean, the Supreme Court, McConnell versus Dudley, foreclosed that type of claim because the court said there is no exception which applies to those claims where there's a governmental function. So unless you were to say that there's a genuine issue of material fact whether police services were being performed, in other words, Officer Soysan was not a police officer performing police services for the village, I don't see how McConnell versus Dudley wouldn't foreclose that claim. I thank you very much, and I would ask you to reverse the trial court in its entirety.
Thank you. The court will take the matter under advisement and issue a decision in due course. When that decision is arrived at, it will be mailed to you by the clerk of court and also be available on the Ohio Supreme Court website. With that, on behalf of the court, I'd like to thank both of you for your presentation this morning.